Good afternoon. May it please the court, my name is Margaret Reed from the Memphis Bar. I'd ask for 2 minutes of rebuttal.
2 minutes.
I represent the appellate, Mr. Eric Meachem, and I will refer to him as father during the course of my argument. This matter also involves the appellee, Miss Andrea Jaye Mosby, who I will refer to as mother, and the party's one child, Emerson, age 12. This appeal arises from a post-divorce relocation matter filed by mother, heard in the Circuit Court of Shelby County. And the issue before the court today is of statutory interpretation of the 2018 amended relocation statute. Today I will show you that the Circuit Court committed reversible error when it, number one, allowed the party's minor child to relocate to Atlanta via order of February 2024. And two, that it committed reversible error again when it entered an amended parenting plan on December 13th, 2024.
Well, there's no issue that this went beyond the 30 days, right?
There's no denying that it went beyond 30 days.
So I want to get into a little bit about the statutory interpretation that you're talking about. Because as I read this, there was a motion filed before Judge Higgins asking her to go back and do something different, for lack of a more eloquent legal term. Is that correct?
That's correct.
Okay. And in her order, she addressed that pretty detailed in her order of April 15th, where she got into the fact that she didn't see a good reason to go back and do anything different.
Well, the Judge Higgins' order was premised off of law that I submit is no longer relevant. In the interpretation of Rutherford interpreted what shall means pursuant to the old relocation statute. And when interpreting what shall means, the court had to look at, and when you talk about what shall means, normally, of course, it is considered mandatory, but there's a different standard that you apply when it's concerning time frames. And so Rutherford, in interpreting the old statute, the use of the word shall for time frames, said that you had to look at the legislative intent. And the legislative intent under the old relocation statute was to mandate a presumption in favor of the relocating custodial parents, the parents who spend a greater amount of time with the child. Justice Kirby, in her concurring opinion in Rutherford, extrapolated on this by noting that the legislature was choosing to drastically limit the trial court's discretion and compress the time frame in which to resolve the matter. And she even went on to say that the legislature was making a public policy decision to permit the non-custodial parent to file opposition, but it had to be within the rigid structure of the statute to get the case resolved quickly. Fast forward to 2018 with the amended relocation statute, and I quote language in my brief from the subcommittee that introduced this bill to amend the relocation statute. And there was repeated emphasis over and over again on the best interest of the child. Specifically, quote, what we are doing is transferring the focus of the court from the moving parent to the best interest of the child. And I think this court has acknowledged in both in Ray Michaela and in Dungy v. Dungy that the new statute does put the discretion back in the court's hands.
Let me ask you a question.
Sure.
And I think we can all agree that the statute changed greatly. The relocation statute did. You know, we can all remember the days when you had to count up how many days they spent with the child spent with one parent versus how many days they spent with the other parent, and you had to, that was kind of your threshold inquiry. Well, things changed a lot with the amendment in 2018, but the requirement for a parent who is going to object to a move, the requirement for that parent procedurally still exists, does it not?
So that language does exist, but that brings us to how do you interpret the word shall when we're talking about a timeline, when it doesn't align with the legislative intent. And the case of Cardoche defined that when you have a timeline like that, two things have to happen for it to be mandatory versus directory. One, the statute must provide a remedy for the failure to comply with the statute, and two, that remedy must align with the legislative intent. So in 2016, we had a remedy. The parent shall be allowed to relocate if the petition's not timely filed. And two, it aligned with the legislative intent that was giving preference to the parents who had the majority of the time. Now we have that same remedy. The language is virtually the same, but the legislative intent doesn't exist.
But did the legislature take any affirmative step to change that language? We reference and talk about all the changes that were made and the amendments to the statute, but if the legislature was going into a overhaul of the statute, which essentially they did, how do you explain that wasn't changed, that the shall language is still there and the parent still has a certain number of days to comply with that requirement?
Right. Well, one thing I would point to is subsection C of the statute. And when you look at that, that provision says, if a petition in opposition is filed, if it's filed, the court shall determine whether relocation is in the best interest of the minor child. It doesn't say if it's timely filed. And so, it can be read, reading that in conjunction with B is kind of contradictory, but it's very clear in C that if it is filed, the best interest analysis shall be conducted.
Would that interpretation of subsection C not essentially render subsection B meaningless?
So I had to attack this on all levels, and so yes, I think that does in some ways render subsection B meaningless, because if that petition in opposition was filed, then the court does need to do the best interest analysis. If this court disagrees, then I go back to the argument that the use of the word shall in this situation, because of the changed legislative intent, is directory instead of mandatory, in which case that would trigger an analysis under Rule 6.02 as to whether or not the time could be enlarged for the party to file their responsive pleading. And in this case, Rule .602, would be applicable for the court to consider whether or not there was excusable neglect. I, submitted to the court in my motion for reconsideration under 59 and 60 the affidavit of Mr. Meachem's previous attorney, whereby he had a medical emergency, a family medical emergency.
And did that information only come up in the context of the motion to reconsider? It did not come up on January 30th when the motion to strike was being argued?
That's correct. But it is kind of a cart before the horse kind of thing, because Judge Higgins was interpreting the statute as Rutherford interpreted it. And so if it's interpreted as Rutherford interprets it, then what the reason was for the delay is irrelevant. It doesn't matter. And so there really was no, if the statute is mandatory, if that language is mandatory, then we don't even get to the reason.
Well, I guess one way of reading the statute is, and by setting tight timelines, you only have 30 days to try to negotiate a new parenting plan, that the legislature may intend that haste is in the child's best interest because you want to get this dispute settled quickly.
And I do think that that's correct. I think in these kinds of cases, it is important to get these issues resolved quickly. There's certainly lines of cases interpreting the 2016 relocation statute where that's acknowledged. A parent may have a job opportunity that they've got to act on quickly, but the legislature changed their focus from that parent's opportunity, or whatever the case may be, to the best interests of the child, which frankly should always be what the paramount consideration is. If the court continues to interpret the new statute under the line of Rutherford, this could lead to crazy, illogical, and disastrous results. And just to throw just kind of the crazy one out there, if a non-relocating parent were to be in a coma and were to received this relocation intent to relocate and didn't file the appropriate opposition, by this interpretation, that kid's going. Whether the relocating parent had nominal time with the child, whether the relocating parent's a drug addict, any number of factors, that child will get to go with the relocating parent if that's how you interpret the statute.
It sounds like you're asking us to employ a more purpose-driven interpretation to the statute rather than looking at the text. Is that what you're doing?
I'm asking the court to follow what the legislative intent was to restore the discretion back to the courts and let the courts make the decision based off of a best interest analysis.
But to get to that legislative intent, and I know you've already argued what was said in subcommittees and things of that nature, to get to that point, then we've got to find that there's some ambiguity as to what the word shall means, don't we?
Well, again, I think when you're interpreting shall as it relates to a time frame, you have to look at the two factors that were established by Cardoche. And that is, number one, the statute must provide a remedy for the failure to comply with the statute. And number two, that remedy must align with the legislative intent. And so if you don't have those two things, you have to interpret shall as directory instead of mandatory as it relates to timelines. Going back to Rule 602 in terms of whether or not there was excusable neglect in terms of the failure to timely file the opposition, the four factors that the court has to consider is, one, the risk of prejudice to the parties opposing the late filing. In this case, the risk was none. The case was being litigated with full knowledge that father opposed the opposition. There was a consent order entered in December setting the matter for trial on its merits. Mother was taking actions, proceeding as if the court was going to hear it on the merits, including filing a motion, asking the court to hear the child's preference pursuant to the relevant section of the relocation statute that allows that. The second factor that the court would consider is the delay and its potential impact on the proceedings. And in this case, there would have been no delay.
Let me ask you a question.
Sure.
Do you have any cases that you can cite to where Rule 6.02 was used to achieve relief in a parental relocation case?
I do not, because the history of cases that we have available to us are interpreting the old relocation statute. I will say that Judge Stafford's dissent in Rutherford outlined pretty clearly why he thought that 6.02 should apply in relocation cases.
I'm familiar with that, but I'm just asking you, do you have any cases where the majority opinion says there should have been relief pursuant to 6.02 for the failure to comply with some time period in the parental relocation statute?
I do not.
Thank you.
Going back to that second factor, there was not going to be any delay in the proceedings. This was set for trial by consent January 30th. The parties, the guardian, the lawyers, everybody showed up that day ready for it to proceed. The third factor was...
Ms. Reed, you're out of time.
Okay.
Yeah.
Thank you.
Thank you. We'll hear from you on rebuttal. Mr. Spence?
Good afternoon. Thank you, Robert Spence, Memphis Shelby County Bar. I'm here on behalf of the appellee and cross appellant. This case really comes down to really one issue, and that's whether or not the appellant has articulated any grounds for this court to not enforce this statute as written, as the trial court did. The argument of the appellant is that this court should not enforce the statute as written and do something else. unfortunately, there's no case law that supports that position. The General Assembly, who passed this statute, didn't provide any relief that the appellant can rely upon. It's interesting that when the 2018 statute was passed, the spirited debate between Judge Kirby and Judge Stafford was a matter of record. And so we are to presume that the General Assembly was aware of that debate. And obviously Judge Stafford in that case, in the Rutherford case, was the dissent. Judge Stafford wrote a concurrent opinion, and Judge Stafford and Judge Kirby was pretty clear about what she thought. She thought that in using this particular language, 6.02 did not apply. 6.02 did not apply, and excusable neglect arguments under 6.02 were just not applicable. Judge Stafford thought the opposite. We are to presume that the General Assembly is aware of that spirited argument in that critically important published opinion. Fast forward to 2018. The General Assembly is presumed to be aware of that debate between those two learned jurists. It sides with Judge Kirby. It does not provide any window of opportunity other than mandatory, strict compliance. And as my opponent just articulated, since 2018, she cannot point to a single case, not a single case in this entire state that sides with the way she views this statute. So,
Is it possible for a parent to waive the response in opposition? I mean, get so caught up in the proceedings that the parent waives a lack of opposition to the petition to relocate?
The relocating parent waive?
Yeah. Yes.
Not under the statute, no.
Yeah, okay.
Because the matter before the court doesn't crystallize until the opposition is filed. Once the petition is filed, it just actuates it.
But here, you would agree, there was some crystallization, to use your term, because on December 14th, 2023, there was an order setting a hearing on the petition to relocate. And by that time, the 30 days had come and gone. So, by your reading of the statute, was no need for that, right?
Well, I believe that it was superfluous. I believe that it was superfluous. I believe that when the 30 days came and went and no opposition was filed, then the statute is actuated. But the court still has to act. The court still has to take some action, but the court is then going to enforce the statute 36-6-108.
Is there anything, and to Judge McBurn's point, is there anything in the record that, and as Ms. Reed said, I don't think either one of you were counsel, maybe when this started. So I'm thinking back through, as having some familiarity with probably how this went in Shelby County. Is there anything in the record that shows us that the court was proceeding along with this, as Judge McBrayer suggested? Or are there just orders setting things and orders that may have just been commonplace of, hi, Judge, we need a date, and a judge signing an order without making a decision on any sort of merits? Am I making that clear?
I think it's the latter, because in January of the applicable year, when the appellant finally filed his opposition, immediately the appellee moved to strike it. So I don't believe that the course of proceedings was anything other than the run-of-the-mill, trying to get things before the court on the calendar to be heard, because even though the appellant had not complied with this statute, the relocating parent, the appellee, still needed a court order that effectuated her ability to relocate with the minor child. And I believe that all of the proceedings leading up to the opposition petition finally being filed was just in the matter of ordinary course. I don't believe there was any waiver or intent to waive or accidental waiver. It was just, how do we get this before the court to get an order that allows the relocation? There is one issue on our cross appeal that I'd like to discuss with you briefly, and it relates to attorney fees. These parents, as the court knows from the record, very acrimonious. And during their proceedings, there were multiple contempt petitions. In fact, the trial court found the husband in contempt on 8 separate occasions, and the mother incurred attorney fees with respect to vindicating the court's orders on those dates. The mother then applied for her attorney fees, and the court only gave her $15,000, and for some reason didn't give her the remaining $46,000 without explanation. just didn't give it. We believe that is error. That's abuse of discretion. There are orders in the record, and we've cited them in our brief, where the father was found in contempt. The vindication of the court's orders were upheld on 8 separate occasions. There's no dispute that the attorney fees to vindicate those orders was incurred. But for some reason, when the court entered its order, the court only awarded the mother $15,000 of the amount that was asked for without explanation, and we are seeking that be reversed, that was error on the trial court's part. Thank you. Appreciate you.
Thank you, Mr. Spence. Ms. Reed, we'll hear from you on rebuttal.
Yes, briefly, just to your comment, I do think that it's possible for the relocating parent to waive the requirement that this opposition be filed. I mean, what is the point of filing the opposition? It's to put the court on notice. It's to expedite the proceedings and get it to a resolution. Everybody knew that this man was opposing the relocation, and we were on track to resolve it, to perform a best interest analysis, and then go to stage 2 of a new parenting plan. The court and the parties were keeping the intent to keep the pace of the litigation. As to Justice Kirby's focus, Justice Kirby's focus was on the legislative intent, which is why that it differentiates between what our situation is now. Finally, of course, his request for attorney's fees, that's, of course, an abuse of discretion standard. The mother prevailed on some of the contempt charges. She did not prevail on many other contempt charges. I would submit that the attorney's fees, the increase in attorney's fees, were directly related to mothers reneging on the agreement to have this heard on its merits on January 30th and taking a different approach. And that is where the fees have substantially increased in trying to get this child to have a court determine what is in his best interest. Thank you.
Thank you, Ms. Reed. All right, the case is submitted. Ms. Dempsey, if you will recess court until 9:30 tomorrow morning.
All right.